Well, hi, everybody. I'm really delighted to be here, and I thank you all for joining into this session this morning. I am a huge fan of Jack's. I've known Kyle Woody since this was just a small spark, and it's just been a joy to watch Jack's grow and grow because the need for caregivers for all kinds of support is just huge, and we see that at Cancer Legal Care all the time. My name is Lindy Yokanovich. I'm the founder and executive director at Cancer Legal Care, but all the information I'm providing today is not cancer specific at all. So if you're here not because of cancer, please know that these issues are nearly universal, and the laws and things that we'll be talking about apply across the board. If I do use cancer as a default example, I apologize in advance. After 20 years, I'm just, and getting older, habits are harder to break. So, in planning out this topic today, the folks at Jack's said that they'd gotten a lot of requests to talk about these issues. So these are the big issues that we'll focus on today. But of course, if you have other questions, we'll tackle them as well. So estate planning, employment law, health insurance, Social Security disability benefits, and then I'm so excited about this new Debt Fairness Act that just passed this session. So I'm telling everybody about it because it hasn't really gotten a lot of press, and it's going to change the lives of any Minnesotan who ever goes to the doctor. So just a little bit about us at Cancer Legal Care. We're here for any person affected by cancer, current patients, people well out of treatment, those who love and care for them, any cancer anywhere in the state. And the reason we serve that large population is because we can't bear to say no to anybody who has the same issue but may have an orphan cancer or something that's not readily in the news. So we serve the entire state. We're almost to every county. We're getting there pretty quickly. We've served over 14,000 Minnesotans and provided over $22 million of free legal services. So you can see there are so many people that need access to this kind of expertise and help and guidance as they make their decisions. But even so, it's just a drop in the bucket for the number of people who are facing these issues. And, I sort of had a laundry list of the issues that we'll be talking about, but you can see that, these issues sort of jump. They're really circular and they're not linear, and things like all these issues come up at different times and impact each other. So if someone's worried about how much time they've taken off from work, they're worried usually about losing their insurance and how are they going to pay for that, and if they can't work, how do disability benefits work? And so it's just kind of a swirl. So really the biggest question that we get from folks is, where do I even start? And the answer is wherever you can practically, wherever you can emotionally, wherever you feel it's the easiest entry point, because so many of these issues are just tied to such emotion and fear. So really, don't beat yourself up. Just start where you can. And then that's quickly followed by, how am I ever supposed to know all these things? And you're not. There is no way anybody knows any of this stuff. You may know a little bit of it from maybe you work in HR, or maybe you helped with your parents' probate. You know how that works. But collectively, these issues are so overwhelming, and they, like I said, they just mush together. That's a very technical legal word, so if you need me to translate the Latin there. They are so intertwined with one another that the collective force of that is really it's just a sense of overwhelm. And we hear that from people every single day. So you're not supposed to know this, but there are people who do know these things. And so, your job is really to just ask questions. And not just ask them, but keep asking them until you understand the answers. Because sometimes you'll just get this long answer that has all these words that and you're still not supposed to understand it. So it's okay to push back and make sure you're understanding. And I think the biggest takeaway after doing this work for almost 20 years is that don't take no from somebody who doesn't have the power to say yes. If they're saying no, that's usually the only power they have, is to say no. If they're the ones who are answering the phones, they have a job to do, and it's not to always make things as easy as it is for the patient or their caregiver. So keep pushing until you can get to the person who can say yes. Keep pushing. See, I was pushing myself ahead there. So starting off with estate planning. One of the biggest questions is, do I really have to create all of these? And, the hardest time to think about all of these is when you're facing a health challenge. The second hardest time to do it is when you feel great and nothing's happening in your life, because nobody ever wants to do these. And it's no wonder. So we've just sort of developed a sort of a flip answer that says nobody ever has to do these, ever, unless they're over 18. And then you have to do these because at 18, you're an adult and all kinds of things change. And that's where these documents come into place. So there's so many. So we'll just do a quick run through about what each one does. So a power of attorney, it is exclusively for financial transactions. And it helps in situations where somebody might need to do the banking on behalf of another person. It's a very powerful document. The power vests immediately in the person you name as your agent, so you really want to make sure that the person being named is incredibly trustworthy. There's this lawhelpmn.org is a fantastic website for anything legal in Minnesota. It has a really great module that you can walk through in creating one of these documents. But then you just need to print it out and go to get it notarized while you sign it. Healthcare directive. That's for your medical decisions. There's a lot of different forms. Your healthcare provider has one. Honoring Choices has a great short form and a great longer form. But that's exclusively just for your medical conditions. So these two documents together are only in power while you're alive. So sometimes people think, gosh, if I have a financial power of attorney, my spouse and I have one, do we really need to do wills? Well, the power of attorney only lasts while the person who's created it is alive. And at the point of death, it no longer conveys any power. So that's the thing to remember. That's why there's so many documents, is because they are not multitaskers. They all just do one thing, the thing that they're there to do. A will, biggest thing to know is that a will does not avoid probate. What it does is it gives the probate court direction on how you want your things, your assets, your property to be passed on. So if you don't have that, people pass away without wills all the time, and there's a whole mechanism that the court then puts into place. But oftentimes, and so the court, if there's no will, then the court would look at, does this person, are they legally married? If they are, then the spouse would get everything. If they're not legally married, then without a will, everything would go to their children equally. But oftentimes, parents may not want that. They can change that if they have a will that gives other direction. And so if there's no children, then it goes back up the family tree to their parents. No parents living, then it goes outwards to their siblings. So there's a whole process for getting your property and assets passed on, but it may not be what you want, and that's what a will does. Minnesota created something maybe 15 years now called a transfer on death deed, and it basically is there because people were having to go through the probate process. Sorry about that. Go through the probate process when their only big asset that had to go through probate was their home. And so this transfer on death deed, it allows you to basically create a beneficiary designation for your home. But it has to be done during a person's lifetime, and it has to be filed with the county during a person's lifetime. But the big benefit of that is that it avoids having to have a probate for your home after you were to pass. And, it's just like any other kind of beneficiary designation to change the title. Trusts, we could, be here for 3 days talking about all the different things that trusts do, but trusts are another more complicated and expensive part of the estate planning packet, but many people do not need that. So are there some simple things you can do to start down this estate planning path? And yes, good news. And you can do these all on your own. You don't need a lawyer. The first thing is to check the beneficiary designations that you have on everything, like your life insurance, any brokerage or investment accounts you might have, retirement accounts like a 401k or an IRA, or if you have an annuity. All these things require a beneficiary designation to be made, but things change because some people might have signed up for life insurance 15 years ago, and now they're divorced and married to someone else, and they don't want their ex to get everything. And so there's many changes. So this is such an easy thing to do on your own and very, very impactful. Another thing to do is add what is called a transfer or a payable on death designation to your bank accounts. So checking, savings, money market accounts, CDs. You can do that and name one or several or many people who you would like to inherit your bank accounts after your passing. And you just need to ask the bank for it, and usually you'll need somebody's social security number or their address, and that's all you'll need. They don't need to sign anything. They don't need to know about it. You can just do it and know that things would be taken care of. So there's basically two kinds of trusts that help avoid income taxes for high net worth people. And then there's what we call revocable trusts that people can create during their lifetime and change. The tax benefit ones you can't change once you put the money in there. The revocable ones you can. And so where that's especially helpful for people is if maybe they own real property in different states, like a cabin in Wisconsin and a home here. They might want to create a trust so that their family wouldn't have to do a probate on the Wisconsin property when they pass, because Minnesota courts can't say what's supposed to happen in Wisconsin. So that's a provision. Sometimes if it's people have minor children, they may want to set up some provisions in a trust to create a trustee who would oversee all the finances for the children while they're still minors or a little older than that. So there's but if you're talking just about strictly trying to pass on a home and your bank accounts, using a TOD and the beneficiary designations can be very, very helpful for the majority of people, because we hear from a lot of people they're at end of life, they've never done any of this work, and they're unfortunately trying to scramble to get it done. And so those are some things that can be done relatively quickly, whereas a trust would take a lot longer. Okay. So probate gets a lot of bad press, and maybe it's warranted, but it's what happens, why something needs to go through probate is if ownership of something, a bank account, a piece of real property, is only in one person's name, and that one person passes away without having done any of the beneficiary type work we talked about or creating a TOD for their home, then the court process has to step in and physically change legally change the title to the ownership of those pieces of property. There's a little escape valve if things are less than $75,000. It can be done relatively easily, but especially for real property, it does take a while. It does cost some money, and it is tedious. But that's why really probate has a place. It also has a place if your family has a lot of contentious relationships, and you think that there's going to be people who are going to be unhappy about decisions that you've made. Oftentimes, probate is, the judge in the room saying, "This is what's going to happen. This is what's going to happen." That's it. So, since I had to do 10 questions, I thought, well, we'll just do some creative numbering here. Is there property that doesn't have to go through the probate process? And yes, just to reaffirm, if there's a beneficiary designation on it, it transfers automatically. The court doesn't need to get involved. Real property that's held in joint tenancy. So if you own a property as joint tenants with your spouse, then on the passing of the first of you, the surviving spouse would own all of it entirely. And then again, the transfer on death deed. Okay. I think that having your mom's voice singing loudly from the documents is the best way to do that. You can't prevent somebody from doing something, but you can do everything you can to stop them from being, successful in their pursuit. So a lot of times in that situation, what will be put in the will is a statement by the testator, the person who's creating the will, saying, "I am intentionally not naming my ex-child because of the following reasons. ... I wish her well. I don't, but I am adamant that I do not want this. I'm very aware of the decisions I'm making." And they just spell that out in the will. And that's when we talked about probate being guidance for the court in a will. That tells the judge, okay, this person, this is what they wanted to do. And you can do anything with your property. It does not matter that you have children. It doesn't matter. You can leave everything to the, three-legged chihuahuas of Chisago County. Dog rescue. You can do all of that, and that's just fine. The only thing that can stop that is if, let's say, a disinherited person who would naturally, but for the will, be the person who would be entitled to inherit. If they can prove that somebody was unduly influencing the person who was creating the will, there was brain fog issues, there was dementia issues, there was, elder abuse, and but. You should probably talk to your attorney, but also sometimes what is recommended when you can see what's barreling down at you is not to have it be a surprise, but to let that person know, I've made a will, I am not including you, and this is why. I will, maybe I have some, things I've set aside for you, and everybody knows that those are for you, but you are not. And because a lot of times it's just it's the surprise coupled with the grief and so if you have a trust set up, you've done all the hard work. Just keep adding things to the trust, or taking things out. But yeah, you're good that way. Okay. All right. So employment leave laws. If I could turn a cartwheel, I would turn many going down and back here, because there is such good news on the horizon for caregivers in Minnesota with new paid leave laws that are happening and are on the books. But, the one that most people think of is the Family Medical Leave Act, FMLA as it's known. And it's a federal law, so it applies equally across the states. And, federal laws create a floor that states can build on and create more rights for people, but states can't dig a basement and take away the rights that the federal law provides. So The FMLA has kind of a complicated calculus, but basically an employee can take up to 12 weeks off all at once or intermittently during a 12-month period. The limitations are that it doesn't apply to everybody. Employers have to be of a certain size, and the employee has to have been there for at least a year. So if somebody's been working at company A for 20 years, full-time, there all the time, changes job to company B, and 2 months later, they need to care for somebody, with a stroke, cancer, they don't have any FMLA rights because they haven't met that threshold of being an employee at that employer, at employer B, for a year. And a common misconception is that it's paid leave. FMLA is not paid leave. It is job protected leave. So it allows people to take this time off to care for themselves or a very close family member and come back to the workplace with their same or similar job waiting for them. Sometimes people have PTO or vacation or sick leave that they can take at the same time. So it gets a little confused because some people say, well, I got paid for my FMLA. Why aren't you? So that's the reason why. And then it has a very narrow definition of who a caregiver can care for and take FMLA. It's a spouse, it's a child, or a parent. So these new paid leave laws that are coming to Minnesota, again, not nationally, just in Minnesota, they apply to all employed people, regardless of how long you've been there. So our person at company B would still be covered by these new laws as of day one of their employment at their new employer. And it has an expanded definition of family. And on one of the 3 sheets there, the earned sick and safe time there, on the front, it has a column of like A through K or something of people who count as family. And it's like this exhaustive list. And then the last one is like, and basically anybody else on the planet who you want to take care of. And the reason that these laws were enacted, and you might be surprised to realize that in Minnesota, 36% of employed people did not have access to 1 day of paid leave. 36% of employed people did not have access to paid leave. And we see that all the time. We see people who are being denied by their employer time off to go to their child's chemotherapy appointment. They can't take time off to care for a parent. They can't. I mean, it's just unbelievable. So these 2 new laws are really going to be a sea change here in Minnesota. So the first one is the earned sick and safe time, and that's the paper that's on your table there. And it went into effect January of this year. And it has a very complicated math, and employers can pick from one of 3 different ways. But basically, people can earn 1 hour of paid sick and safe time for every 30 hours they work. So people can accrue this time off, and once they can take it as they earn it, and it's to really it's an expanded to care for yourself or to care for another person who's sick or been the victim of domestic violence or stalking, or there's a weather concern with travel. So the safe time piece is a whole new thing beyond what FMLA would ever provide. So then Minnesota paid leave is coming in 2 years, I guess a year and a couple months now, January 2026, and it's going to provide up to 20 weeks of paid leave in a 12-month period. And so it's going to provide for up to 12 weeks to take off for your own health condition and up to 8 weeks as a caregiver. And so this is going to be funded by a payroll deduction. Part of it the employer will have to pay, part of it the employee will have to pay. There's an option for the employer to cover the employee's piece as a benefit. And then it's going to be administered by the state of Minnesota, much like the unemployment process is now in Minnesota. This, I just can't even imagine. I mean, we have so many clients who cannot take any paid leave off. They don't have any access to cover their time away from work for their treatment or to care for somebody. So this will really be a huge change. There are, as you imagine, a million things to work out. So I don't have a lot of specifics to provide other than this, but I'm happy to answer anything that I do know. If folks have any questions. Maybe we can just gloss over this one because I know nobody ever has any problems with health insurance. It's all just such a joy. But it is so stressful. And about 5 years ago at Cancer Legal Care, we started a program because there were so many egregious denials of our clients' cancer treatments. There were just unbelievable billing errors that were happening that would just seem to be so easy to fix, but it's like trying to unring a bell. And so we started doing this work. We do it at absolutely no charge, and there's no income limits because, if there's no attorneys doing this work. There are no attorneys in private practice that are really representing patients to do this because there's no money in it. People don't have the money to pay, and the amount of time it takes to pursue these is unbelievable. So, did you have a question? Oh, okay. So some tips. Get one notebook and write down everything in it, every call that you have with your insurer, all the information, their name, time of day, date, and what you talked about and what they said. And the reason why this is so important is because, when sometimes you get these, you're on hold and you hear, this call may be recorded for training purposes. You as a patient have a right to get a transcript of that recording. And sometimes we have used that to say, your representative told our client this would be covered, or this doctor was in network, or yes, this is authorized. And then when a denial comes, if they have that time and date, we can go right there and make a request that they provide that transcript. So super important. Setting up online portals with both the insurance company and your providers, very helpful if you need to file an appeal. Another thing is to really compare the charges on your bill against, the eventual bill you get against the onslaught of EOBs that you receive. And then to make sure that the bill charges match the amount that they're saying you owe or the patient responsibility. And this is a big one. I have to say, I don't even have this for our new policy, but you really want to get the full copy of your policy, not the 15-page PDF that you can get from the website, but the whole 150-page, giantly boring document, because there are super wonky attorneys that we work with who just love to read that stuff and find what they need to have an appeal be successful. Read each EOB and understand the charges. Each charge has a reason code. And if that reason doesn't make sense, flag it, and that's something you can go back to your insurance company about. Rarely do people appeal insurance denials. And it's easy to understand why. They're exhausted, they're overwhelmed. How are they going to do this on their own? It's just one of those things that just gets pushed off, and it drives a lot of healthcare decisions. If something's denied, people will say, well, I guess I just won't get that treatment then. And they are overwhelmingly approved when they are denied. So it doesn't cost you anything to appeal something. There's a whole list of how the appeals have to go forward in any denial that you get. And they have to, it has to be reconsidered in your appeal. And there's a very good chance it'll be overturned. And if you're having trouble affording your bill, talk to your provider. They all have a financial assistance program, and the laws are changing around that about their requirements to make that known to patients. There's also an organization called $4.org that we have worked with and vetted, and they do a lot of help in helping people get payments for their medical bills. We usually refer people to Senior Linkage Line or some of the federal agencies that are working with Medicare. And for any of you who have felt completely bamboozled by trying to figure out Medicare, we have a health insurance advocate who was a health insurance executive for 40 years, and it took him a year to figure out, like, do I do straight Medicare? Do I do the Medicare Advantage plan? I mean, it's confusing. It just really is. And, you know, things are starting to change. I don't know if you've heard in the news that, like, Health Partners dropped United Healthcare because of their prior authorization, just denials. And, you know, it's happening more and more. So I think there's a growing recognition of just how, like you said, these algorithms just do this denial. There is no human being looking at these, and trying to get a human being to look at these is really challenging. Another thing that people can do if they're completely at their wits' end is to contact one of our United States senators or your representative, because oftentimes they can push through the bureaucracy. And we've done that. Sometimes we're like, we've tried everything we can. You should get in touch with Amy Klobuchar or Tina Smith's people. And sometimes that just is what it takes. It's a fix for that one person, not the whole system that so greatly needs it. Mm-hmm. Thank you. And so National Patient Advocate Foundation. And what was the other organization that works? Start Senior Solutions for. Okay. Great. All right. Let's keep going here because we have a few other topics. Social Security disability benefits. Again, where do you start? It's so challenging to figure out. If you remember nothing else from this talk, never Google Social Security and go to the first link. Always type in ssa.gov. You can create an account on ssa.gov. Everybody can do that, and it'll show you what your anticipated benefits would be at retirement, or if you become permanently and totally disabled before your retirement age. The attorney who does this work with us, she says don't wait to look into applying. A lot of times folks they're so worried about applying for this because they really want to go back to work in the future. And there's a mechanism to be able to go back to work in the future. But if you're going to be out of work for at least 12 months and you don't have any other financial resources, this is your best bet. It's really challenging to be approved. It's a very high standard for disability that they use. And the waiting time once you are deemed eligible is 5 months, but the way Social Security does the math, it's really 7 months until you actually receive the cash benefit in your bank account. So don't worry about applying with your hope of going back to work. You can go back to work in the future. Another thing we advise is not to be working full-time when you apply. They will not approve. You have to be so disabled that you're unable to work. Mm-hmm. Mm-hmm. Right. Yep. So there was a question about the compassionate allowance, which is a list of diagnoses that Social Security says if you are diagnosed with one of these conditions, in the cancer world, very generally speaking, not all the time, but it's a stage 4 cancer that is metastasized, will put you on that compassionate allowance list. But you still have to have that 5-month wait once you're not able to work. So we have lots of people who contact us and they have stage 4 cancer, but they're still working full time. So they've met the definition is that you have one of these, diagnosis that's permanent or expected to last 12 months or reasonably result in death. And it's so disabling that you're unable to work and earn at least X number of dollars. And it's usually about $1,100. So if you are working and earning more than that, by Social Security's definition, you are not disabled because you haven't met that second part of the definition. So, but the reality is, how do you go? And the clock starts ticking when those two things come together, when you don't earn that much and when you have that diagnosis. And that's when the 5 months start. If you have it and you start going out, well, yes, that's ideally how it's supposed to happen. But a lot of people don't have that. There's no requirement that employers provide short-term disability. And this is this incredible catch-22 people are in because they really should stop working. Their physicians begging them to stop working, but they can't financially bridge this huge 5 month, which is really 7 month gap in between getting any income in. There's two types of disability insurances through Social Security. One is SSDI, Social Security Disability Insurance, and I stands for insurance. And that basically means that you've worked long enough and recently enough that you've paid into the system. And so your cash benefit is going to be directly related to how much you've earned over your lifetime. SSI, Supplemental Security Income, is for folks who don't have that long and consistent work history. So they have to still prove the same level of disability. But with SSI, you can get Medicaid, which we call medical assistance here in Minnesota, very quickly. If you have that SSI benefit, and sometimes people can get both, but it's a very narrow window for people who can do that. So if you're getting SSDI, and you're approved, at the end of that 5 month wait period, you have a 24-month wait until you're eligible for Medicare. Okay, so it's the 5 months of the wait period plus 24 months after that. So 29 months where you've got to cover your health insurance, either through COBRA or by going on to the MNsure exchange and looking for a plan there, going on to a spouse's plan, going on to medical assistance. You know, the average SSDI payment, I believe, is about $1,600 a month. And, you know, a premium on MNsure could take up a goodly portion of that. So it is an impossible situation for many people. So the payments start at the 7 months, but let's say you were a person who you had this diagnosis and you stopped working. Okay, you were able to make it on your spouse's salary, or you moved in with somebody, or you had savings, and you didn't apply for Social Security disability then. So then let's say a year later, you decide, you still haven't gone back to work. You decide, you know what, everyone's telling me I should apply. Social Security will say, you know, your disability date was way back there 12 months ago when you were disabled and you weren't working. So they will give you a retroactive payment back to 12 months. If it's more than 12 months, they won't. So another thing besides remembering typing in ssa.gov is that people do not need to go to one of those horrible attorneys on late night television and hire them to do this. Call us. We will cheerlead you from the side, because what happens is those attorneys then, there's a statutory fee of about $8,000 that they take, and then they'll take a portion of that back pay if you have back pay. So, you know, the experience is people are going to need, whether it's 2 months of back benefit or not. So the only time you'd really need one of those attorneys is to do an administrative appeal, but then you wouldn't need one of those attorneys, and we'll tell you who to go to. So yes, I used to be more judicious in my comments, but the world is burning, so I just tell the truth. And then finally, you don't need to gather all your medical records that you've had since time immemorial to apply. Go to your portal, put the diagnosis information in there. You can apply yourself. You can apply online. You can have a caregiver can help somebody apply. and you can come back to the application. But you don't, Social Security is going to get your medical records because, people would just pick and choose which records they're going to send. So you don't need to mail off a big box of medical records to Social Security. But and don't wait till you have everything perfect. Sometimes it's just better to look at the application, see what it is, do it in stages, and not worry about having everything perfect before you apply. Okay, so we're almost to the end here. Minnesota just passed a Debt Fairness Act, and those of us who are in the collaborative are calling it 1.0 because we're coming back next year for more things to change. But it is going to have a huge impact on people with medical debt. And all of the provisions went into effect by October 1st of this year. And they include that a patient's medical debt will no longer be automatically transferred to their spouse upon their death. Minnesota was one of only a very small handful of states that had this. 3. Yes, very small that still had this. And it was a devastating reality in Minnesota. And so, a lot of people are like, I want to pay my debts. That's fine. You can do it. But no other debt that's held individually is automatically transferred to a person's spouse. Student loan debt isn't done that way. Credit card debt in one person's name isn't automatically transferred, but medical debt was. So now this is a huge, huge change. For a long time with this, we didn't know, is this only going to be for debt that's acquired after October 1st? And what's going to happen to all these people who up to October 1st are, have a mountain of debt? And Keith Ellison's office has put out a statement saying that their position is that it's all medical debt going backwards because as of October 1st, there was no mechanism to be allowed to collect that. I'm sure it will be litigated, but that's the position that the state of Minnesota is taking. Medical providers will not be allowed to withhold medically necessary care for people who are carrying a balance. There was a big story about that in the news about this time last year. Medical debt cannot be reported to credit bureaus anymore. So this is especially helpful for people who are carrying a large balance that they validly may owe, but they're just, they may have had good credit before that, and now they have this huge mark on them. Medical debt is inherently different than consumer debt, and it's not going to be treated that same way in being reported to credit agencies. Agents can dispute medical coding and billing mistakes, and there's unethical collection practices will be stopped. So, most important question of all, no, do not go on Google because every state's laws are different and there's just a lot of misinformation out there. So if you really do have to search for something, again, lawhelpmn.org is a great and very trustworthy site. If you have friends, family in other states, lawhelp.org is sort of the global site, and they can go in there and find their state's equivalent to this. The Minnesota Attorney General's office has a lot of great information on insurance, on debt collection, on consumer law, things dealing with auto loans. There's just an unbelievable amount of information there and help. And then if you're dealing with cancer, you can feel free to, of course, call us. Even if you're not, you can give us a call and we'll try to guide you the best we can. So, when we started 18 years ago, nobody understood why we were here, but so many of us cared for parents who were dealing with these issues. We dealt with them ourselves. And so we started. Our very first grant came from the Lance Armstrong Foundation, back even before it was Livestrong. So now we are funded by foundations like the Otto Bremer Trust, the Richard M. Schultz Family Foundation. We just got our first funding in from the American Cancer Society this year, so that was great. We were one of 15 organizations nationally that were funded by addressing barriers to care because so many people are dealing with this. We have a couple of contracts with the state and then individual people who, realize that this is such vital help. Our budget is about $800,000 a year. We have 9 employees and about 70 volunteer attorneys around the state. So we are pretty scrappy, pretty sassy. And we just, it's just gotten to the point where these issues lived in the shadows for so long. I mean, way back in 1980, my mom had colon cancer when I was in high school, and we lost our health insurance before the protections of the Affordable Care Act's, prohibition against discriminating against people with pre-existing conditions. And there was nowhere to go. And, my parents felt so ashamed that, that this had happened. And so these issues are happening in almost every family. And so for folks like you who can help spread the word about the resources that are available in Minnesota, I mean, that's really how the word gets out. And, we do a lot of work with great organizations like the ACS and JAX and Gilda's and MOCA that's here. So really, any one of us will help you get to the next spot. But it's not like this in every state. Well, enjoy the rest of the day. Thanks for supporting JAX. And I'm happy to stick around if anybody has any other questions. Thanks again.